on the left, it is people generally argue for what is called a living constitution. They believe that judges should import their judgment about society and its cultural mores into their decisions on what the Constitution says. That is, so they believe that the court must and cannot help bringing its own prejudices and predilections into its decision making. But the absolute core of the judicial philosophy of those on the right, the conservatives, is originalist in the case of constitutional questions and textualist in the case of statutory interpretation. And what the whole core of their idea is that you can separate your own views on a matter with a decision about what the law says.
Welcome to The Debrief, where we talk with the Washington Examiner's top journalists about the headlines they're covering this week and where the story's going next. I'm Sarah Westwood, and I'm here today with Editor-In-Chief Hugo Gurdon. And Hugo, there's pressure from the left right now for Justice Amy Coney Barrett to recuse herself from an upcoming Supreme Court case because of her religious beliefs. Set the scene of what's going on with that.
Yes, on Monday, December the 5th, the Supreme Court is going to be considering a case in which a website designer, Christian from Colorado, is trying to defend her right, establish her right to build and design wedding websites without being obliged to make them for same-sex weddings. This goes right to the heart of the First Amendment, the free exercise of religion. It's obviously, it's according to her religious convictions that she believes that marriage is a sacrament between one man and one woman. Mm-hmm. Doesn't believe that she should have to make websites for same-sex couples. And it's also, there's the thought that if she's obliged to make sites for same-sex couples, that's forced speech, and that contravenes free speech. So the court will be deciding whether or not she is entitled to participate in the economy of Colorado without having to breach her religious beliefs.
What do you think this sort of pressure campaign on Justice Barrett from the left says about how the left views the judiciary?
It's a fascinating thing, Sarah, that the on the left, it is people generally argue for what is called a living constitution. They believe that judges should import their judgment about society and its cultural mores into their decisions on what the Constitution says. That is, so they believe that the court must and cannot help bringing its own prejudices and predilections into its decision making. But the absolute core of the judicial philosophy of those on the right, the conservatives, is originalist in the case of constitutional questions and textualist in the case of statutory interpretation. And what the whole core of their idea is that you can separate your own views on a matter with a decision about what the law says. For the left, the personal is always political. For conservatives, for constitutionalists and originalists, they say we can separate these things, and we will separate these things.
And finally, the ruling in Masterpiece Cake Shop, which, for those who don't remember, was the, I believe, 2018 case that involved a baker, also in Colorado, who did not want to make a cake for a same-sex marriage. The Supreme Court ruled in the baker's favor, but narrowly.
Right.
Do you think that this case could better be able to distinguish the balance between religious freedom and same-sex marriage rights?
Yes, I do. I think that there's more chance here that there will be a broader ruling. The composition of the Supreme Court was different back in 2018. There are two more constitutional originalists and textualists, that is to say Amy Coney Barrett, who we've just been talking about, but also Justice Kavanaugh was not on the court at that time. And I think that with the 5-4 or sometimes 6-3 textualist and originalist majority on the Supreme Court now, it's more likely that there will be a more sweeping decision and ruling, which more clearly defines the rights of Christians to, their protections under the First Amendment to the exercise of their religion, their free speech, etc. Than there was in the past, when you could get bigger majorities, but that's because the rulings were narrower.
Well, Hugo, thank you so much for being here today. You can get more reporting from Hugo and the rest of the commentary team at washingtonexaminer.com.